The FOP and IACP also seem concerned about the officer's precious qualified immunity. The bill goes further and provides that any person who is deprived of any right, privilege, or immunity may sue a law enforcement officer who would not be afforded qualified immunity. This makes it impossible for any officer to conduct any investigation with respect to ascertaining if the person is in fact compliant with the firearms laws in their state of residence. It would also expose the officer to civil liability if, for example, they were to secure the firearm while they conducted an investigation into other suspected criminal activity. This is another example of how law enforcement uses their vaunted qualified immunity to infringe on the rights of others with impunity. Look at what the legislation actually says. A person who is deprived of any right, privilege, or immunity secured by this section, under color of any statute, ordinance, regulation, custom, or usage of any state or any political subdivision thereof, may bring an action in appropriate court against any other person, including a state or political subdivision thereof, who causes the person to be subject to the deprivation for damages and appropriate relief. The court shall award a plaintiff prevailing in an action brought under paragraph 1 damages and such other relief as the court deems appropriate, including a reasonable attorney's fee. If law enforcement officers deprive someone of a right secured by this legislation, they can be sued. Is that such a crazy idea? According to the FOP and IACP, even if you present a facially valid carry permit from your state of residence, you are considered guilty until they can prove that you are innocent. But that is not the way jurisprudence is supposed to work in this country. You are innocent until proven guilty. And if the documentation you provide is facially valid, meaning on its face it looks valid, and it's presumed to be valid, the law enforcement has no reasonable, articulable suspicion that you are committing a crime. According to the Supreme Court case Terry v. Ohio, in justifying the particular intrusion, the police officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant the intrusion. Generally referred to as reasonable articulable suspicion, or RAS, that the subject has, is, or is about to participate in a crime. This RAS is required by all law enforcement in all situations outside of a warrant to detain or search a person. In effect, the FOP and IACP are arguing that law enforcement needs to be exempt from the restrictions of the Fourth Amendment and any consequences for their violations. This is confirmed later in the letter where we find the bill also seems to cancel any qualified immunity for the officers, as the right of Americans to keep and bear arms is guaranteed by the Second Amendment. Qualified immunity protects officers from civil liability unless they violate clearly established statutory or constitutional rights. Any action the officer may take in reaction to the knowledge that the person they have encountered is armed could place that officer in very real legal peril. Apparently, the FOP and IACP forgot that not only is the Constitution, of which the Second Amendment is a part, the supreme law of the land, but that each and every law enforcement officer they allege to represent took an oath where they swore or affirmed to support it. As the letter points out, the right of Americans to keep and bear arms is guaranteed by the Second Amendment. This legislation clearly recognizes that right, meaning any officer who violates that right is not covered by qualified immunity. It's almost as if the FOP and IACP don't want their law enforcement officers to be held to the same laws they enforce on others. Officers would be expected to interpret and apply laws from all 50 states in real time without reliable means to verify an individual's eligibility to carry concealed weapons, especially those from permitless carry states where no physical permit exists. This leaves law enforcement unable to confirm lawful possession during encounters, creating confusion and heightening risk in high-stakes situations. However, officers are not expected to interpret laws from any other state, merely to assume that if someone presents a facially valid license, they treat it as a valid license in their state. As things are today, not only do gun owners need to know and interpret the laws from any of the 50 states they wish to visit, but know whether or not that state currently respects their carry permit and the rules by which they do so. Again, it appears the FOP and IACP don't think their officers should be required to follow the laws that we do.